instances of laws, public policies that are in violation of basic human rights. So let's start with a few of them here. There is, for example, a provision, Section 86, dissemination of means of propaganda of unconstitutional organizations. Even this title is a bit problematic, because an unconstitutional organization, well, what does that mean? That means that the Constitution considers it something that is undesirable. Those who wrote the Constitution, those who amend the Constitution, don't like these organizations. And sometimes they don't like them for very good reasons. But does that make them an offense against anybody? Does that make them an assault on anybody, an invasion of anybody, an aggression against anybody? No, not necessarily. Just because if a Constitution does not confine itself to protecting the rights of individuals, but extends itself in ways such as refining the thoughts of the citizenry, then it will contain all kinds of measures that may be offended by human actions and thoughts of some of the citizenry without actually doing harm or violence to anybody. If a Constitution says that you may not exhibit, as the Constitution here, by the way, does say, certain signs, say the swastika or the Red Cross or whatever, and that becomes unconstitutional, does it mean that this unconstitutionality deserves to be honored? Well, not any more than simply because it's being enforced. And so the only backing for its unconstitutionality is that there is the legal power to suppress those things, but it doesn't mean that there should be that legal power. And from a political, philosophical, legal, jurisprudential point of view, the real issue is whether something ought to be unconstitutional, not whether something is unconstitutional. I mean, constitutionality is a matter of the will of policymakers, including maybe the citizenry in its democratic processes, but even that does not fix something as actionably wrong. Actionably in the sense that there ought to be legal provisions against it. So if a Constitution mistakenly incorporates provisions that prohibit certain kinds of conduct, especially speech and thought, then it is questionable whether there's anything wrong with being unconstitutional. Why should it be? I mean, a Constitution can have all kinds of provisions that it ought not to have, and that may have entered into the Constitution as a matter of hysteria or panic or a feeling of weakness. It is indeed something arguable that when a legal order goes overboard in prohibiting expressions of offensive ideas, that this is actually a sign of the weakness of the legal order and a kind of an admission that it can't cope with ideas that are offensive, that are arguably corrupt in a peaceful and intellectually effective way, that it must use the force of arms of the state to overcome these ideas. Well, in a genuinely free society, at least the way I understand the free society, when you meet up with ideas that are bad or offensive or corrupt, you're supposed to deal with it with other ideas that are not bad, that are not offensive, that are not corrupt. You're supposed to engage in debate, and you're supposed to ferret out the bad ideas by means of argument and by means of discussion and brainstorming. And you have somebody who presents views that you find very upsetting and that are wrong-headed. You invite somebody else who presents better ideas, and that's the way you come combat ideas not by prohibiting them by law. This is a general provision. It has nothing so much to do with Germany, but it does suggest that failing to abide by this provision of a just rights respecting human community suggests that the country in which these measures are admitted into the Constitution and into public policy is not quite confident in itself. It needs to have these measures, and by that means, oddly enough, it undermines the very defense of its basic principles. It's very interesting that a couple of wording here, for example, one says you're supposed to discourage or prohibit organizations that engage in the use of propaganda within the meaning of subsection 1 shall only be those writings, it says writings, the content of which is directed against the free democratic constitutional order or the idea of international understanding. Now, how can you have a free democratic constitutional order which prohibits the criticism of the free democratic constitutional order? That's a contradiction. That basically undermines that very freedom that the constitutional order is supposed to embody and contain. You don't have that in a free constitutional order. A free constitutional order implies, in part, that citizens are not prevented from criticizing it, even wrong-headedly, even mistakenly. It's not the business of the Constitution to correct people's ideas. That's the business of discourse throughout the community, of educators, of intellectuals, of pundits, of writers, and so forth, not of the legal authority. The legal authority's business in a genuinely free society is to defend freedom. And to defend freedom, it does not involve suppressing thought and speech. It involves suppressing or banning hostile action, aggressive action that is attacking people for whatever reason they're attacking them, whether the reasons are nice reasons like trying to build something that you believe in and then you go against people who don't believe it. That too would be a form of suppressing freedom. Generally speaking, almost all of these provisions which try to guard against subversion in a society, subversion of the ideals of the society, tend to undermine those ideals and do very little else. Now, the fact is that some people probably are chicken enough to respond to these laws in a compliant way, that they will agree not to speak out, but they will basically take their protest into a different dimension. Instead of speaking it, instead of writing it, they will make it a secret organization or a secret undertaking. And so even for a utilitarian point of view as to the practical impact of these provisions, which I consider a violation of human rights, it's very questionable whether they are even successful. And they can't really be very successful since they are themselves violations of the very rights that the Constitution is supposed to protect and secure for people. So since they are like that, they probably cause more damage to the integrity of the Constitution of a free society than the people who are attacking that society. One of the provisions of a genuinely free legal order is that it protects the rights of highly objectionable people. It's easy to stand up for the rights of normal, well-behaving, civilized human beings.